In a custody case, what are you supposed to say to a judge? Good question. Well, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. You know, people always wonder, what am I supposed to say? I'm going to go to court. I'm going to have a hearing. What am I supposed to do? What should I emphasize? Well, number one, the court is going to want to know that you got some plan that promotes the best interest of your child. So you want to emphasize in your testimony before the court what that plan is. You're going to bring this child to school. It's going to be the best schools. You're going to help the child with the homework. You're going to take care of medical needs. You have this means of support. These are things that the court wants to hear details about. It is also important to detail a consistent history of stability, a consistent history of caregiving to the child. In other words, the court is going to consider you as a custodial parent. The court is going to want to know that you're reliable to give a healthy environment for this child, that you have a history that supports that reliability. So these are kind of important things. And how do you do that? You provide organized documentation of your involvement with the child. In other words, just coming in and saying, well, I can do this and I can do that, that doesn't mean anything. Show the court evidence. You prepare an evidence book that details all the things that you've been involved with, the plan that you have, all the medications that the child's, all the appointments that the child has. Show the court that as a caregiver of this child, you're going to be the one that most and best promotes the child's best interest. And that's what you're going to ultimately need to do. You need to, not only that, you need to express the willingness to foster a positive relationship with the other parent. Now, some people think that their main goal is to show that they're the best. But no, the court also wants to see, since there's a nationwide movement toward a joint situation, the court's going to want to see that even if they give you custody, that you can work with the other parent, that you'll have a working relationship for parenting time, for child support issues, other issues that come up. Why? Because the court doesn't want to have to deal with you every single Wednesday in Oakland County. The court doesn't want to hear motions every single day. The court wants to know that the parties are capable of working it out themselves, at least for most issues. So the court is going to want to see that there is some sort of potential of a working relationship. You therefore have to be respectful to the court. You got to be factual. You got to be concise through your testimony in terms of what you can do, but you also have to show the court that you have a respectful relationship with the other side and that you are willing to work with them to promote the best interests of the child in raising this child in the best custodial environment possible. Now, if you have any questions about your particular case, reach out, and of course, we'll be glad to help you out.